Good morning. Let's see here. Unmute. How are you, Donna?
I have a cold. I just woke up with a cold this morning.
Oh no. Have you ever tried
Tomorrow.
airborne? Oh darn it. I know when I'm starting to get a cold, I'll take airborne and that always seems to help. So
I
maybe
think I
try that.
have some, or some coldies or something.
Yes, something to fight it so it doesn't get too bad.
Yeah.
Well, good morning, Catherine. I know it always seems like that's when, when the weather changes, that's when everybody starts getting sick.
Yeah.
Darn it. Oh, there's your kitty.
Yeah. Yay.
Oh, what is your cat's name?
This is Reed.
Oh, Reed.
She has a sister named Gabby.
Oh, Reed. Reed. I miss my cat. Well, go ahead and get started. Okay, so I'll mute everybody and we'll see you guys in just a little bit. All right. Let's see here. All right. So we're going to start out with some words. Okay, here we go. Ready? Satisfied, samples, mistake, stating, intended, field, length, pudding, informed, purchased, satisfied, exactly, available, hair, snow, satisfaction, outside, inside, properly, superintendent, lonesome, included, selling, figure, 50, perfectly, truth, west, keeping, excellent, awaiting, district, pass, telegram, heavy, October, study, learn, advice, include, opening, similar, allowed, loss, average, offered, entitled, promise, transportation, death, worse, besides, looks, arrangements, easy, move, wouldn't. All right. I have a phrase drill here. You're going to hear at which time, after the accident, to the, for the, right hand, which is R&D, how wide, H-O-U-D, at that time, at all times, within the. So this is just a basic phrase paragraph, okay? Okay, I'm gonna read this at, I'll read this at 180 and we'll do it again at 200 and then at 225. Mr. Carter was rushed to the hospital after the accident, at which time he was treated and released with minor injuries. The accident occurred when Mr. Jones failed to stop for the traffic light. He made a right-hand turn from the right-hand lane onto a one-way street. He could not determine immediately how wide the bike lane was, and at that time, he hit Mr. Carter. Mr. Carter at all times had remained within the bike lane. All right, so again at 200. Mr. Carter was rushed to the hospital after the accident, at which time he was treated and released with minor injuries. The accident occurred when Mr. Jones failed to stop for the traffic light. He made a right-hand turn from the right-hand lane onto a one-way street. He could not determine immediately how wide the bike lane was, and at that time he hit Mr. Carter. Mr. Carter at all times had remained within the bike lane. All right, so again, I'm going to read this at 225. I'm just dating this. All right, here we go. Mr. Carter was rushed to the hospital after the accident, at which time he was treated and released with minor injuries. The accident occurred when Mr. Jones failed to stop for the traffic light. He made a right-hand turn from the right-hand lane onto a one-way street. He could not determine immediately how wide the bike lane was, and at that time he hit Mr. Carter. Mr. Carter at all times had remained within the bike lane. All right, so I've even got my watch set at 250, so I'll go ahead and read it one time at 250, okay? Here we go. Mr. Carter was rushed to the hospital after the accident, at which time he was treated and released with minor injuries. The accident occurred when Mr. Jones failed to stop for the traffic light. He made a right-hand turn from the right-hand lane onto a one-way street. He could not determine immediately how wide the bike lane was, and at that time he hit Mr. Carter. Mr. Carter at all times had remained within the bike lane. All right. Again, that just focused on those particular phrases. Now I've got a contraction drill for you. You're going to hear I'm, it's, your, we'll, he'll, they'll, that's, we're, there, I'll, you'll, he's. All right, here are your sentences. I'm not happy with the outcome of the lawsuit. I'm planning on visiting you this summer. It's the last day of the month. It's up to you if you want to stay. You're better off taking Route 85. You're definitely one of my best friends. We'll leave at 10:30 p.m. We'll need to contact the coroner. He'll have to have a blood test. He'll send for his personal effects in 1 week. They'll probably ask for proper identification. They'll hold the inquest at 4:45 p.m. I am sure that's not my gun. I feel that's the only way to discourage him. We're planning on guests for dinner. We're hoping to hear from Mr. Jones before Friday. They're going to attend West Point in the fall. They're currently in courtroom number 12. I'll be glad to send you a copy of the will. I'll be looking forward to meeting your brother. You'll have to send the letter by registered mail. You'll be glad to know he's now a notary public in the state of New York. All right, moving right into names and addresses. Here we go. Ms. Marty Tumbush, T-U-M-B-U-S-H, Marriott Hotel Resorts, Dayton Marriott Hotel, 1414 South Patterson Boulevard, Dayton, Ohio, 45409. Ms. Peggy J. Ha, H-A-U-G-S, Omni Venture Ltd, 1648 TCF Tower, 121 South 8th Street, Minneapolis, Minnesota, 55402. Ms. Donna Berg, B-E-R-G, Los Alamos National Laboratory, Los Alamos, New Mexico, 87545. Ms. Bonnie Brands, B-R-A-N-D-S, Handicap Village of Northwest Iowa, 330 Village Circle, Sheldon, Iowa, 54201. Ms. Marilyn B. Mayer, M-A-Y-R, Department of Audit, Milwaukee County, 907 North 10th Street, Milwaukee, Wisconsin, 53233. Jenny Bushman, CPS, Ingalls Memorial Hospital, 1 Ingalls Drive, Harvey, Illinois, 60426. Sil Haynes, H-A-N-E-S, South 30, Mentor Avenue, Pasadena, California, 91206. Ms. Martha L. Slaughter, S-L-A-U-G-H-T-E-R, 359 Oak Grove, Parchment, Michigan, 49004. Ms. Ernestine White, W-H-I-T-E, Best Products Company, Incorporated, P.O. Box 26303, Richmond, Virginia, 22260. Ms. Karen R. Simon, S-I-M-O-N, Culinary Institute of America, Hyde Park, New York, 12538. Sandy L. Mock, M-A-U-C-K, Rust-Oleum Corporation, 11 Hawthorne Parkway, Vernon Hills, Illinois, 60561. Barbara J. Kuchler, K-U-C-H-L-E-R, El Paso School District, 4931 Hercules Avenue, El Paso, Texas, 79804. Mr. Keith E. McCoy, Atlantic Research, 7510 Wellington Road, Gainesville, Virginia, 22065. Mrs. Annette W. Rebovich, Fountainhead Apartments, 295 Turnpike Road, Westboro, Massachusetts, 01581. Mr. Andy S. Morales, M-O-R-A-L-E-S, 701 North Brand Boulevard, Glendale, California, 91203. Ms. Clarissa Ashley, A-S-H-L-E-Y, 529 Southeast State Street, number 3, College Place, Washington, 99824. Ms. Lee Ann Paff, United National Bank, P.O. Box 1348, 9th and Phillips Avenue, Mill Falls, South Dakota, 57101. Pamela Overton, Energy Tech Division, TRW Energy Development, One Space Park, Redondo Beach, California, 90278. All right. I have a letter by letter spelling drill with domestic cars. All right. Here we go. The vehicle inventory sheet for Friday, August 3rd, 2014 indicated that the following cars are currently being leased. A 2000 Buick, B-U-I-C-K, a 2011 Oldsmobile, O-L-D-S, M-O-B-I-L-E, a 2009 Pontiac, P-O-N-T-I-A-C, a 2013 Cadillac, C-A-D-I-L-L-A-C, a 2010 Ford, F-O-R-D. Does this information agree with your latest inventory report dated Monday, August 6th, 2014? All right. I've got some Tangle Tamers. Here we go. Immaterial change, homicide involved, resisting arrest, former mistress, inherited stock, ambush, slaying, request denied, first spouse, improvident agreement, marital relations, limited edition, divorce proceedings, parties' intentions, insurance, broker, undenied right, facts offered, speech slurred, undeniably true, attempt deception, constitutes murder, coition act, subsequent return, disability incurred, final approval, fiscal year, council decision, popular belief, cause existing, principle relied, many instances, marital status, public relations, annulment decree, police dispatch, accident scene, articulate counsel. All right. Moving into our next drill. This focuses on when, was, what is. One of my favorites here because it's such a high, it has such a high rate of, errors. I think it's a great drill. It's all of the basic ones that we usually miss. All right, here we go. I'm going to give you the phrases before I give you the sentences. Here we go. Was he, when is, was she, what is, what was it, what were, was this, when are, what are, was gone, what would, was that, what will, was done, what shall, was not, what can, was said, when can, what could. And then here are your sentences. What is going on? Court was adjourned then. What is the matter? What is the time? What is the sentence? What is the problem? When is the ruling? The attorney was late. When is it happening? What is the statute? When is the trial date? What is our option? What is happening? What is the trial date? What is our chance? Where is the exhibit? What is her name? What is the law? When is the decision? What is the book? What is this book? When is the decision? What is the decision? What is the code section? What is wrong now? It was too late to file. When is the verdict? What is it I said? What is to be done? What is finished? What is your opinion? When is to be done? What is the ending? When is it being done? When is the evidence going to come in? What is it you said? The opinion was good. What is that for? What is now in print? What is the truth? When is the time limit? What is so important? What is his secret? What is your position? What is your question? What is his theory? When is your theory? The ruling was reversed. What is the difference? What is the best way? When is his treatment? All right, moving right into initial consonants that start with initial TR. right. Here we go. No treasure is worthy of treason. Visiting the Treasury building is a treat. They signed the treaty under a tree. It was a long trek to the trellis. The trembler caused us to tremble. Some tremors are tremendous. The soldiers tremored in the trenches. Today's trend is trying to tramp. Her tresses were trailing. A triad tried to trip us. Trial transcripts are trying at times. The trolley transported the trollops. We had a troupe playing trombones. Don't trifle with the tributary. A tropical trophy from the tropics is terrific. The true trucker played a trump. Truman tried to create trust. He trusted the trunk to the troops. Truants tried to catch trout. He tripped over the trite truism. Some of those are tangle twisters there. All right, I'm going to go into literary. And this literary is called Problems Shared by Businesses, Part 1. And so I'm going to give you a word list. Okay, you're going to hear universal, institution, issuance, financing, merger, varied, credit, administration, facilities, management, competition, partner, forfeited, research, and capital. Okay, so I'm going to read this. I'll read this at 180. Right, here we go. Most of the problems that exist in large businesses also exist in smaller businesses, but to a different extent. All businesses are faced with universal problems, which include financing, management, competition, and research. Whether large or small, businesses all have a need for capital to get started and to expand. Sources of capital are widely varied and can range from a friend or relative to a large financial institution. Establishing a credit rating is another difficult process. Small business owners frequently borrow from friends or relatives, savings, or the Small Business Administration for loans. Accepting a partner or partners is another way of obtaining capital, although some degree of control in the operation is usually forfeited at this time. Larger businesses may acquire additional capital through the issuance of stock, mergers, sale of existing facilities, and loans from banking institutions. I'll read that one more time at 200, okay? Here we go. Most of the problems that exist in large businesses also exist in smaller businesses, but to a different extent. All businesses are faced with universal problems, which include financing, management, competition, and research. Whether large or small, businesses all have a need for capital to get started and to expand. Sources of capital are widely varied and can range from a friend or relative to a large financial institution. Establishing a credit rating is another difficult process. Small business owners frequently borrow from friends or relatives, savings, or the Small Business Administration for loans. Accepting a partner or partners is another way of obtaining capital, although some degree of control in the operation is usually forfeited at this time. Larger businesses may acquire additional capital through the issuance of stock, mergers, sale of existing facilities, and loans from banking institutions. I've got terrible allergies today. Sorry about that. All right. I'm going to give you some legal terms, and then I will read you this paragraph. It's all on legal terms. You're going to hear trustee, bankrupt, referee, creditors, bankruptcy, receiver, solvent, initiated, voluntary, debts, federal, officer, disposition, involuntary. And then bankrupt, you can write that as B-R-U-P-T or B-A-R-P-T. I've heard it either way. Bankruptcy, B-R-U-P-T-S. Okay, and here is your paragraph. A person who is unable to pay his debts is called a bankrupt. Federal courts have been established to handle bankruptcy cases. A voluntary bankruptcy proceeding is initiated by the bankrupt party. when the creditors of the bankrupt party start the bankruptcy proceedings, it is called involuntary bankruptcy. A court officer in charge of the bankruptcy proceedings is a referee. A receiver follows the orders of the court when disposition of property is necessary. A party is solvent when he can pay his debts and insolvent when he cannot pay his debts. A trustee holds the bankrupt's property for the creditor's benefit. So I'll read that one more time at 200, okay? Here we go. A person who is unable to pay his debts is called a bankrupt. Federal courts have been established to handle bankruptcy cases. A voluntary bankruptcy proceeding is initiated by the bankrupt party. When the creditors of the bankrupt party start the bankruptcy proceedings, it is called involuntary bankruptcy. A court officer in charge of the bankruptcy proceedings is the referee. A receiver follows the orders of the court when disposition of property is necessary. A party is solvent when he can pay his debts and insolvent when he cannot pay his debts. A trustee holds the bankrupt's party or property for the creditor's benefit. All right, moving right into jury charge. You're going to hear reasonably, necessity, circumstantial, objects, proof, combination, inference, deduction, material, senses, testimony, non-existent. You're also going to hear direct evidence, which I'm sure you know, but just in case, it's DREFD. Here we go. And I will read this at 200. Ladies and gentlemen of the jury, please concentrate on my definition of the meaning of evidence. Evidence consists of the testimony of witnesses, written material, material objects, or anything perceived by your senses that is offered to prove the existence or non-existence of a fact. Evidence may be either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. By itself, if found to be true, direct evidence does establish the fact. Circumstantial evidence is evidence that, when found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may be reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that the facts be proved by direct evidence. They may also be proved by circumstantial evidence or by a combination of direct evidence and circumstantial evidence. Both circumstantial evidence and direct evidence are acceptable as a means of proof. Neither one is entitled to more weight than the other. You must weigh the evidence in this case, both direct and circumstantial, and arrive at a verdict in this case. Okay. I'm going to give you another jury charge selection, and I will read this at 200. Here we go. That case, Your Honor, as I know the court is aware, did address the issue of credibility of the witness, and that case is different from this case in that it appears that the witnesses in that case were going out of their way to tell the truth. They weren't trying to do anything other than help by saying what they knew, and there was some talk that they might very well be mistaken. Then there was a fingerprint from an unknown person, and the court, after consideration, and I am mindful that most of that case actually dealt with the jury selection and the issues, but I think of the motions as not being designed to test the credibility of the witnesses, and I have viewed that as a jury duty, but I would submit to the court at some point the witnesses can be so bad that they are not worthy of belief. And I don't believe that's the people's fault. It is the witnesses' fault. This court has had the opportunity to see Mr. Ray and Mr. Salazar, and I know you don't need reminding on some of the things that have happened in this trial. Perhaps the court has seen more bizarre testimony. In my experience, I haven't seen people lie to a jury, get caught, lie again, admit that they hurt themselves in grand jury, admit that they hurt themselves at the trial, and it has just been an amazement to me. Maybe I am naive. Maybe I haven't done enough trials in the 30 years I have been practicing. I have done hundreds, but if a reasonable trier of fact can base the case on their testimony, then I should lose this motion. The problem is having to do with my client. There is also no physical evidence once his confession is suppressed. And I am mindful that the court did suppress a statement that, to all intents and purposes, is tantamount to a confession. And if we look at the evidence that this jury has been permitted to hear, there is no physical evidence to corroborate the statements of Mr. Ray and Mr. Salazar. There are no letters that my client wrote or that my client is mentioned in. There is no DNA evidence where my client has bloody clothes or things of that nature. I am mindful that the prosecution could say, well, Ray and Salazar have answered that by saying that those clothes were disposed of. There is no fingerprint of my client in the car, and we all know that you can be in a motor vehicle and not leave fingerprints. But when we go through all of the evidence, in order for the jury to convict my client, they have to rely on the testimony of Mr. Ray and Mr. Salazar. The prosecution, I am sure, will point to the how did they know certain things, such as how did they know that the verbatim and the victim had been stabbed in the head? How did they know whether there were phones at the gas station? Things of this nature. But when we look at everything that's been presented, it certainly seems that the testimony of Mr. Ray and Mr. Salazar is not worthy of belief to the trier of fact. I would like to make a motion, based upon the lack of evidence and the standard, of course, being evidence of what we are talking about here. As to Mr. Hugo, the only evidence against him is the fact that he may have been in the car when the car returned to the house. There is nothing in the letters about him. Nobody ever talks about him. He may have been at the funeral, not at the funeral, but the evening gathering or the mass on the 1-year anniversary. He may have been, but we are not really sure. Right. Let me just date this. How are we doing on time? Okay, yeah, we're doing okay. All right, I'm going to give you guys one more piece of jury charge. This is, the subject is common carrier. Okay. All right, here we go. I will read this at 200. Ladies and gentlemen of the jury, a common carrier is one who undertakes for hire to transport from place to place the goods or persons of those who choose to employ him. The defendant in taking and transporting the machine here in question was a common carrier for hire. Generally, a common carrier of goods ensures the safe transportation of the goods committed to him for that purpose, and he is responsible for all of the damages to the same while in transit. There are, however, certain exceptions to this rule. One of these exceptions is if the loss or damage arose solely from the fault of the shipper himself, that is, if the goods or freight transported is improperly packed or improperly loaded by the shipper, and this fact is not apparent or known to the carrier, and the carrier is not at fault himself in causing the damage, then the carrier is not liable for the loss or damage resulting from such improper loading by the shipper. It cannot be said, however, that the shipper must have known that the machine was not in fact safely loaded. The shipper usually knows better than the carrier the manner in which the goods have been packed or loaded and the manner in which they should be packed or loaded. And even though the carrier may have knowledge of some defect in the packing or loading, still, if it is apparent to the ordinary observation of the carrier that the goods cannot be safely carried in the condition in which they are presented, the carrier should not be held to take the chances of damage or injury from such improper packing or loading. The burden of proof rests upon the defendant to prove by the preponderance of the evidence that the loss or damage arose solely from the improper loading by the defendant. All right. That was at 200. We'll go ahead and get started with our Q&A. This is going to start with plaintiff. Actually, this is just plaintiff and the witness. All right. Here we go. I'm going to start, let's see here. I'll start at 180 with this one and then work my way to 200, okay? Kind of get warmed up with the Q&A. And then the next selection we do, I'll start at 200 and go to 225. Here we go. How long did you know Mr. Stewart? Since 1995, that would be 15 years. Did you meet him through coaching at Cleveland Community College? Yes, I did. Did you know him on a social basis as well as a working basis? Yes, I did. Did you consider yourself a close personal friend of Nick Stewart's? Yes, I did. What kind of person would you say that Nick was? He was a quiet, competitive, and a very moody person. Did he complain more than most people? Yes, he did. About what? Primarily the relationship with his students. How often would he complain about his relationship with his students? Would it be consistent, constant, or once in a while? Once in a while, occasionally. What was the nature of his complaints, if you can recall? Nick was a former running back with the San Diego Chargers. He was a good football player. He was a perfectionist. If the students were sloppy or careless in their work, it bothered him. He would have confrontations with them about their problems and become quite upset. Do you have any opinion as to how often he confronted students because of their sloppiness and carelessness? No, but it seemed to be a constant thing. In the 15 years or so that he was an instructor as a coach, can you give us an estimate as to how many times he complained to you that he was extremely upset with one of the students? On the average, I would say 2 to 3 times a month. He would complain about 2 to 3 times a month about the students? Yes. Why would he mention that to you? Just to vent his anger, I guess. I think, as I told you, I talked to Nick primarily on a daily basis, and when we would talk, things would come up as a matter of normal conversation. Did you ever hear him complain about the operations of the college itself? Like, for instance, he didn't have enough equipment available or learning materials or something like that? I am just asking. I would say yes on occasion. I would have been surprised if everything ran perfectly. It would be out of the ordinary, no different than any other college. Was the administration pleased with his performance? As far as I know, they were. You also said you knew him socially. Did you ever play golf with him? Yes, sir. How often did you play golf with Nick? Every Saturday. Did you know that was one of Nick's hobbies, was collecting guns? Yes, I did. Were you aware that Nick owned a .22 caliber rifle, a .45 caliber revolver, and a .357 caliber Magnum, along with a .38 caliber special revolver? Yes, I knew that. Were you aware that Nick kept a small handgun in his office desk on campus? No, I was not aware of that. Did you ever hear Nick threaten a student with physical harm? No, never. Did Nick ever tell you that he contemplated taking his own life? He only mentioned it to me once. Do you remember when that was? Yes, it was several years ago after the death of his wife in an automobile accident. Was he extremely depressed at that time? Yes, he felt his life was over. All right, so I worked my way up to 200 there. And I'm just dating this so I know that we covered it. All right. This is going to be defense questioning and deposition format. I'm going to start this one at 200 and then work my way to 225. Okay. All right, so you're going to hear Benjamin Peters. Let me say that again. Benjamin H. Peters. Manhattan Rentals. Newspaper route supervisor. Machinist. Equipment. Mr. Hooker. Interesting name. Vice president. Existent house trailer lot. Specialty trailers. Manhattan Rentals Corporation. Mr. Nichols. That's about it. All right, so we're going to start. This is defense questioning. At the time of your deposition, you stated that your name was Benjamin H. Peters, Jr. Is that your proper name? That is correct. How old are you, Mr. Peters? 49. When did you go to work for Manhattan Rentals? Approximately 4 years ago. Yes, it was 4 years ago last June. Now, you have been earning a livelihood since you left college, haven't you? That is correct. Since that time, you have earned your livelihood as a small loan businessman, among other things. Is that correct? That is correct. As a bill collector, I really have never collected bills. All right, as a machinist, that is correct. As a newspaper route supervisor, that is correct. Prior to going to work for Manhattan Rentals, you were never in the trailer leasing business, were you? No, I wasn't. You never worked for anybody in the trailer leasing business? No. You never worked for anybody in any leasing business. Is that correct? That is correct. You were never in the business of working for somebody in the business of selling any kind of vehicles or equipment? No, sir. Now, you were hired by the plaintiff as a salesman. Is that correct? That is correct. A salesman in the trailer leasing industry in the sales department. That means the leasing and selling of trailers, doesn't it? The renting and subsequent sale of some of them, yes. On occasion in the industry, there are original sales too, aren't there? Yes. At the time you were hired, were there other salesmen in the sales department? No. At the time you were hired, Mr. Hooker was the president, was he not? That is correct. And Mr. Nichols was the vice president, is that correct? That was not the proper title. What was his title? He was selling trailers off the existence house trailer lot or the existent house trailer lot. Did he have a title? I don't think so. Now, at the time you were hired, the business of Manhattan Rentals Corporation was the leasing or selling of the office and specialty trailers, was it not? Yes. And you were hired as a salesman, is that correct? That is correct. Was it your main function to build the business? Yes, it was to learn the business and build it. Now, approximately 6 to 9 months after you were hired, you were put in charge of all the sales except for several house accounts. Is that not correct? I believe it was earlier than that. It was before 6 or 9 months? I believe so. Approximately how long after you were hired was it? I would say 4 or 5 months. And you were put in charge of all of the sales except for the several house accounts? That is correct. And this was at your insistence, was it not? That is correct. And isn't it true that during that 4 or 5 months, you were working under the guidance of Mr. Hooker and Mr. Nichols or Mr. Nicholas? Well, Mr. Nicholas gave me more help than Mr. Hooker ever did. All right, so I'm just going to date that. And I started at 200, worked my way to 225. All right. This one is going to start with plaintiff. Plaintiff attorney. You're going to hear Harry's Grill, Newman, Chicago, underwriter, policy, Springfield, broker, fixtures, conditionally, Metropolitan, Purcell, Theodore M. Brady, correspondence, coffee shop, moral, interruption, Mark, Illinois, blanket, insurance, underwriter, let's see here, L.E. Pruitt. All right, so it's going to start with plaintiff, and defense does come in. This is actual four voice, okay? Defense and the court both come in. I will start at 200. Here we go. Mr. Brady, do you know a Mr. L.E. Pruitt? Yes. Had you discussed the insurance on the fixtures in Andy's Grill and Bar with Mr. Pruitt? Yes, I did. Did you ever have any correspondence with Mr. Pruitt regarding the fixtures for the restaurant? I received no correspondence from him. I wrote him one email after a couple of telephone conversations. Do you remember what was the nature of your conversation? What did he say to you, and what did you say to him? As I recall his office, I contacted his office after getting a phone call from Mr. Newman's secretary stating that Mr. Pruitt had called them and had told them that Mr. Parker didn't want us to write any insurance on this property, that Mr. Pruitt was going to write all of the insurance for them. Please continue. Then I called Mr. Pruitt's office and explained to them that this contract, this master policy that we have, requires that all conditionally vended property be included under the blanket policy. Then as a favor to him, I called the Metropolitan Underwriter's office in Chicago, Illinois, and asked them if they cared to make an exception in this particular case. And I was advised by the head underwriter, Mr. Purcell, that he could see no reason why there should be an exception, that the contract provided that all conditional sales should be included under the policy. Okay, so go ahead. I advised Mr. Pruitt by email that we were going to send it. Okay, that you were going to send what? That we were going to send out the policy. Do you have any way of establishing the dates of these conversations you had with Mr. Pruitt? Well, they were prior to November 18 because it was on November 18 that I emailed Mr. Pruitt, November 18, 2010. Then it was November 18, 2010 that you sent Mr. Pruitt an email informing him of this. That is right. And in your conversation with Mr. Pruitt, did you inform that this policy that Mr. Newman had? Your Honor, I will object to the leading questions. That will be sustained. Did you inform Mr. Pruitt of the nature of the policy? I will object to the leading question, Your Honor. Sustained. The email is the best evidence. Okay, do you have a copy of the email that you sent to him? Yes, I do. May I see it, please, sir? May I approach the witness, Your Honor? Yes. I have here an email to L.E. Pruitt Insurance Company, and it is signed by Thomas M. Brady. May I have this marked plaintiff's next in order for identification, Your Honor? Yes, it will be marked plaintiff's 18 for identification. May I approach the witness, Your Honor? Yes, you may. To clarify this is an email you wrote to Mr. Pruitt after you had discussions with him regarding insurance on the fixtures in Andy's Grill and Bar. Is that right? That is correct. Would you read the email to us, please? Yes, November 18, 2010, L.E. Pruitt Insurance, 5028 Main Street, Springfield, Illinois. Subject, Andy's Grill and Bar. Dear Mark, I didn't get back to the office in time to call you this afternoon, and since I am not planning on being in the office tomorrow morning, I decided to send you an email. This afternoon, I went to West Springfield Fixtures and discussed the matter with Mr. Newman. He stated that Mr. Parker had been in his location yesterday and mentioned nothing about the insurance and wanted to talk with him about it before making any decisions. He got Mr. Parker on the phone while I was listening on a third line. Mr. Parker said that he was well satisfied with the coverage under this certificate and he wanted to leave it as it is. I trust that you will be able to write the rest of the line for him. Thank you, Brady and Morrell Insurance, T.M. Brady. Okay, Mr. Brady, you indicated that you had been an insurance broker for about 3 years. Prior to that, what was your business or occupation, sir? I was in the insurance claims for approximately 13 years. May I approach the witness, Your Honor? Yes, you may. Are you familiar with the business interruption insurance? I am. I call your attention to People's 5 in evidence. This appears to be an insurance policy. Yes, it is. And is it a business interruption policy? Yes, it is. What are the limits on that policy? If you can tell by looking at it, sir, the face amount of the policy is $550,000. In the event of a business interruption, how will this be paid to the owner of the business? Well, I would have to examine the policy quite carefully to tell you. Does it state an amount per day on that? Yes, it states the rate of $4,000 per day. I have no further questions. Right. We're doing on time. Good. So I started at 200 and worked my way up to 225. Okay. And this again is going to start with the plaintiff, and it is a court format. So you're going to have defense and the court jump in. Okay, you're going to hear interlocutory decree, dissolution, furniture, equalize, Carolyn, Flagstaff, First Federal, Arizona, redundant, administrative, Bishop, medical, Gerald, trustee, petition, furnishings, remittance, separation, Maureen, distribution, preliminary. Looks like that's about it. Okay. All right. So this is going to start with plaintiff. Here we go. We'll start at 200, work our way to 225. The interlocutory decree of dissolution of marriage contains a statement that to equalize the distribution of furniture that you were to be paid $5,000 by Mrs. Sherman. Did you ever receive $5,000 from Mrs. Sherman? The former Mrs. Sherman, I am trying to remember. Let me refresh your memory. The interlocutory decree of dissolution of marriage contains language which states that to equalize the division of the furniture and furnishings, your former wife was to pay you the sum of $5,000. Have you ever received a payment for remittance or payment in any form from your former wife in the amount of $5,000? I can answer the question, yes. I only asked one question. Maybe I'm confusing you. No, I didn't receive any money. You never received any money? I never got the $5,000. Now, I asked you in preparation for your testimony today to prepare a list of items which you feel, if you received them, would equalize the division of the property. Do you recall my asking you to prepare the list? Yes, I do. And I'm going to show you a list. I previously furnished a list to counsel that you have prepared in your own handwriting, and I will show you this list. Dr. Sherman, if you received the items on that list, in addition to those items which you have already received, would you be content with the division of the furniture and furnishings? Yes, I would. I would ask that this list be admitted as Exhibit D, Your Honor. Any objection? No objection. It will be received in evidence as Exhibit D. Will you hand that to me, please? Thank you. Proceed, Mrs. Delaney. Okay, Dr. Sherman, you further requested in your moving papers that certain bank accounts which existed on the date of separation, which were not divided in the interlocutory judgment of dissolution of marriage, be divided at this time. Is that correct? That's correct. Your Honor, I would like to furnish the court with a variety of bank records from First Federal Savings and Loan in Flagstaff, Arizona, which I would ask be admitted into evidence. They've been set and sealed envelopes, and both counsel have examined the records. Okay, any objection? No objection, Your Honor. Okay, they will be received as Exhibit E and so marked. Let the record see it, Mr. Clerk. Go ahead. So received. Dr. Sherman, did you separate from your wife, Carolyn Sherman, in March of 2014? Is that correct? That's correct. Your former wife's petition alleges March 4 of 2014. Is that correct? I believe that's correct. The records before the court indicate that there was on March 4 of 2014 an account with First Federal Savings number 9-5307-51 existing on the date in the amount of $40,599.14. Did you at that time have any knowledge of the existence of the account? I don't recall having any knowledge of that account, no. First Federal Savings also had an account which on March 4 of 2014, number 9-5306-85, had an approximate amount of $70,861.75. Just a moment. Give the numbers again, please. Yes, 9-5306-85. Okay, all right, proceed. Now, go ahead. Okay, now you had an account at First Federal Savings with you and Carolyn, which was an amount for your daughter, Mia. Is that correct? This was for your daughter, Mia. Was the approximate amount of the account $70,000 at the time you separated? No, Carolyn had her own account. She was the trustee for Mia's account. I'm not on that. Okay, but you were aware of the account? Oh, yes. Is it your request, Dr. Sherman, that the property be divided equally? That's my request. Dr. Sherman, you make a further request that the value that was originally placed on your medical practice be reduced because of administrative proceedings, which resulted in your repaying some of the medical overcharges and attorney's fees, which you incurred as a result of the proceedings. Now, for preliminary purposes, I was not your attorney in those proceedings. Is that correct? Yes, that's correct. And you have alleged that you have had to repay Anthem $30,000 for 2 years prior to your separation. That's correct. What year were you required to repay Anthem for? In 2008. And have you in fact repaid them that amount? Yes, I have. In resolving those claims and going through the administrative hearings, that resulted in the amount being assessed against you. Did you incur any attorney's fees? Yes, I did. Who was the attorney that represented you? Gerald A. Bishop. Do you have any objection? I think it's redundant, Your Honor. Right. How are we doing on time? I think we have time for one more. Now this one is going to start off with the court, and then it's going to go right into recross. Okay. All right, here we go. Does that figure include the $16,098.80 on Schedule C? Yes, sir, it does. Okay, well then is $59,669.40 the total loss? Yes, sir. Rather than the $75,000 plus as alleged in your cross complaint? Yes, sir. I have nothing further at this time, Your Honor. Very well, counsel. Thank you. Mr. DeSalvo, I am referring now to a document entitled Answers to Interrogatories dated August 15, 2013. This was the loss as originally computed, I believe. Is that correct? Yes, ma'am. I figured that the Darien, Connecticut in about September of 2012, and I figured it from the best available records that I had at that time. And although this document was apparently verified by Mr. Chamberlain, it was from information that you had furnished to him. Is that correct? Yes, ma'am. Now, obviously, there are some changes on it. And the figures now, rather than $75,000 plus, it says $59,000 plus. Is that correct? Yes. Now, you correct me as we go along here if I am wrong. As I understand your testimony, the $6,411.13 is still a correct figure? Yes, it is. How about the $14,353.20? Is that still a correct figure? I don't know. I have got $13,353.20, and the last 5 digits are, 6 of the 7 digits are the same. I don't know whether this is a 13 or a 14. It's essentially the same. Can I look at something else here? Sure, go ahead. Something in here. Yes, go ahead. In here, I would say that either I made a mathematical error or that there is another error here, but the total number of the total numbers here, mirrors, claimed hasn't changed. If you were to take a minute, could you figure out whether this $13,353 is correct or the $14,353 is correct? Well, I will say the $13,353 is correct because I see it's been corrected on here. Do you see that here? Yes. So with respect to the loss from mirrors cut, there has also been no changes between August 15, 2013 and your testimony today in the figure of $6,410.13. That's right. Yes, ma'am. And the only change in the next item, loss from mirrors sold at 20 cents a foot, is $1,000, which apparently was a mathematical error originally. Is that a correct statement? Yes, ma'am. Then now, do you have an extra copy of what you are referring to? Yes, I am looking at the summary of loss. Okay, now the next figure, loss from sale of reject vanity mirrors on this schedule that you have just handed me, entitled Summary of Loss, shows $26,098.80. On the answers to interrogatories on August 15, 2013, it says loss from sale of decorative mirrors. In other words, it doesn't mention vanity mirrors in that one. But are we talking about the same loss there? No, there has been a change in that. Well, I mean the same type of loss. Same type of loss, yes, ma'am. What is the change that accounts for the increase from $20,593.68 to $26,098.80? Can you explain that increase? Yes, when we left here on Wednesday with instructions to get some variable figures together, we went back to the Hartford office and we were able to determine from the more complete records there that in fact, surprisingly enough, all of the vanity mirrors had been sold. Had been? Yes, ma'am. And they had not been sold on August 15, 2013? No, ma'am. I don't think they had been. I didn't have the complete records when I was back in Darien. When these interrogatories came in for answer in August of 2013, were they sent back to Connecticut for you to answer them? I never saw them before. Well, you must have from what you have just said. You prepared this and sent it to Mr. Chamberlain, did you not? I prepared this document in September of 2013. I am sorry, counsel. What are we referring to? Counsel, we need a clarification. I am referring to Exhibit A attached to the answers to the interrogatories with the mailing affidavit of August 15, 2013. That was in answer to interrogatory number 18, set forth in exact detail the computation of damages in the amount of $75,583.26, as alleged on page 5, line 1 of your first amended complaint. Thank you, counsel. All right, so that one I read more at 200 because I kind of felt like it was, more on the challenging side because of all the numbers. Okay. Let's see. Was that challenging, that last one with all the numbers?
For me, it was.
Yeah. And I'm sure because you're dealing with numbers but that, it was a little faster than 200, but not quite at 225. So, I would say the second half I picked it up. I went a little past 200, but I thought, I don't want to 225 because I know when I have a hard time reading 225, I know you guys are, it's more challenging for you. So, yeah. So, any questions about any of the material we covered?
No, I think when it's that technical like that, it's hard for me to turn off my brain to just go, don't think about what it means, just write the words.
Yes.
It's good practice to do that because sometimes you don't know what they're talking about. It's scientific or like that, lots of numbers, and just have to just type what you hear, not try to understand.
Right. Yes. And like this one, it kind of throws you off. When I was reading through it, marking it, I was thinking, yeah, it might throw you off because you don't really hear about mirrors very often. And they're talking about vanity mirrors and, different types of mirrors. And at first, when I was reading this, I thought, wow, this is different, because it's talking about the rejection of, losing money from these vanity mirrors and, decorator mirrors. So it's like a different topic. So it is good just to not worry about it and just say, okay, whatever comes my way, I'm going to write whatever comes my way, Yeah. Because you never know. You're going to hear everything under the sun,
Mm-hmm.
So, well, thank you guys for joining the live class.
Thank you.
Appreciate it. It makes it so much more fun when I've got students in here.
Of course.
So, all right. Well, you guys have a great day.
You too. Thank you so much.
You are welcome. Oh, real quick, Donna, and you can stay in here too, Catherine, but I had a student who I looked to see if I had your number and I was going to email you, but a student had some questions about like the RPR that you recently took. And I was wondering if I could pass your number along.
Yeah, sure.
Okay. Yeah.
You still have my number on your phone?
I don't know. So I can email you and then maybe you can email me back.
Sounds good.
Okay. That sounds great.
I don't even have your number still somewhere too.
Here, let me give you mine. Because I always give it out anyway. So let's see, 728-8342. And I can
I've got
you or whatever you want to do, but yes,
I'm going to text you right now so you have my number.
Okay, perfect. Right. Yeah, I thought I saved it, but I guess I didn't when you had texted me that time. So
yeah, you can give it to her or whatever. It's fine.
Okay. That sounds great. Okay, you guys, Catherine, have a great weekend. Donna, have a great weekend.
Thanks.
Okay.
See you later.
Thanks, guys.
See you next time.
Yep. See you soon.
Bye, Donna.
Bye.